All right, settle down, class. Welcome. Take your seats and open your notebooks immediately. I am your professor for today's lecture, and I'll tell you right now, I am adopting a strictly exam-oriented approach. Today, we are dissecting question 20 of your syllabus, defines sale, rights, and liabilities under the Transfer of Property Act, 1882. Now, you know as well as I do, this is a classic 16-mark essay question, and I will not accept mediocre responses. In this explainer, I am going to literally dictate the exact answer script structure required to score full marks. Pay close attention to this layout because it is designed exactly how your answer booklet needs to look. Here is your mental blueprint. 1. Introduction. 2. Definition of sale, section 54. 3. Rights and liabilities, section 55. 4. Doctrine of caveat emptor. 5. Landmark case laws. And 6. Conclusion. Memorize this exact sequence for a flawless 16-mark KSLU answer. All right, let's dive in. Heading number 1. 1. Introduction. Center this neatly right at the top of your answer booklet. Structure is absolutely everything in law. Governed by the Transfer of Property Act, 1882. Rights and liabilities mainly provided under sections 54 and 55. Let me sternly remind you right now, opening your answer by citing the exact bare act and section numbers immediately signals your academic competence to the evaluator. Always start with the statute. Moving on, heading number 2. 2. Definition of sale, section 54. Prepare your pens, class, because you are about to write the most critical definition of this entire essay. A transfer of ownership in exchange for a price paid or promised or part paid and part promised. Mark my words, you must memorize this perfectly. Do not alter a single syllable. Reproduce it word for word. The evaluator is looking for statutory exactness, okay? Not your creative interpretation. Beneath that definition, you've got to break down the key elements. Transfer of ownership. Property must be immovable. Consideration must be price, meaning money, must be effected by a registered instrument for immovable property. Listing these 4 bullet points clearly, that secures the very first 4 marks of your answer. By doing this, you are showing the examiner that you truly understand the anatomy of Section 54. Next heading. 3. Rights and liabilities, Section 55. We're now transitioning to the substantive, heavy portion of the essay question. This right here is where the bulk of your 16 marks will be awarded. Underneath heading 3, create a subheading, Part A, before completion of sale. I strongly advise you to clearly separate the timeline of the transaction in your written answers. The law treats the parties very, very differently before the conveyance is executed versus after. First, we have the seller's rights. 1. Right to rents and profits till ownership passes. 2. Right to interest on unpaid price. Now look at the seller's liabilities. 1. To disclose material defects under Section 55, subsection 1, Clause A. 2. To produce title documents. 3. To answer buyer's queries. 4. To execute proper conveyance. 5. To take reasonable care of property. Drawing a comparative table exactly like this in your answer script saves the examiner time. And let me tell you, an examiner whose time you save is an examiner who awards full marks. Now, corresponding to the seller, we have the buyer. Look at the buyer's rights. 1. Right to inspect property and documents. 2. Right to get good title. 3. Right to specific performance. And the buyer's liabilities. 1. To disclose facts increasing value if known. 2. To pay purchase price. 3. To bear loss after ownership passes. Balancing the seller's obligations with the buyer's obligations directly adjacent to one another, that shows a comprehensive, masterful grasp of the statute. Now, put down your next subheading. Part B, after completion of sale. You absolutely must mark the shift in legal responsibilities once that conveyance is officially complete and registered. Look at how the post-completion matrix changes for the seller. Seller rights. 1. Right to unpaid purchase money functioning as a charge on the property. 2. Right to sue for price. Seller liabilities. 1. To give possession. 2. To transfer ownership free from encumbrances. The absolutely crucial point here is emphasizing this massive shift. The seller goes from maintaining the property to basically having the sheer right to sue for their money or enforce a charge. Finally, dictating the post-completion matrix for the buyer. Buyer rights. 1. Right to possession. 2. Right to rents and profits. 3. Right to benefit of improvements and accession. Buyer liabilities. 1. To bear losses after transfer. 2. To pay public charges and taxes. I am issuing a stern warning here, class. Do not skip any of these post-completion buyer liabilities if you want full marks. Paying public charges and bearing subsequent losses are fundamental statutory duties. Move to your next major heading, 4. Doctrine of caveat emptor. Before we even touch the case laws, you must introduce this overarching common law doctrine that governs property transactions. Write down the maxim, let the buyer beware. I instruct you to literally underline this exact phrase in black ink on your KSLU answer scripts. It absolutely must stand out. Following the maxim, note these principles. Buyer must exercise due diligence, subject to exceptions, namely fraud and misrepresentation. Make sure you elaborate in your paper that stating the exceptions proves advanced, mature legal reasoning to the evaluator. It demonstrates you understand that while the buyer must beware, the seller simply cannot actively deceive. Now, heading 5, landmark case laws. Listen to me very carefully on this. Citing precedents is strictly non-negotiable for a 10-mark or 16-mark answer. Without case laws, your answer is merely an incomplete summary. Raghunath Prasad, Deputy Commissioner of Pattabgarh, explained obligations of seller. I want you to write this case law in a separate, neatly drawn box format in your answer script to immediately capture the KSLU evaluator's attention. Now, do not just name the case. You must explain its relevance. The brief background here involves a dispute over undisclosed material details by the seller. The final ratio decidendi laid down by the court is that the seller's statutory obligation under Section 55 to disclose material defects is absolute and cannot be easily contracted out of. The absolute relevance of this case? It completely fortifies the seller liabilities we just discussed in Part A of your matrix. It proves that a failure to disclose vitiates the fairness of the transaction. Underline the case name. The second case you must cite, Narandas Karsandas v. S.A. Kamtam. Clarified nature of transfer of ownership. Again, I mandate that you box this case name as well. Now, the facts of this case revolved around a dispute over whether a mere agreement to sell creates an interest in the property. The verdict, the ratio decidendi, explicitly clarified that in India, unlike English law, a mere agreement to sell does not create any equitable estate or interest in the property. Ownership only transfers upon execution and registration of the sale deed. And the relevance? It perfectly anchors the Section 54 ownership concepts you established at the very beginning of the essay. It shows the evaluator you can actually connect the statutory definition to supreme judicial interpretation. Write down your final heading. 6. Conclusion. You must draft a precise final paragraph to tie this whole thing together. Draft this conclusion word for word. The law balances rights and duties of seller and buyer to ensure fair and secure transfer of property. Section 55 provides a comprehensive framework governing their relationship. Ending your essay on this precise, balanced note leaves the evaluator with a perfect final impression of your legal acumen. It proves you understand the jurisprudential purpose behind the Bear Act. So, class, I leave you with this question. Have you actually mastered the matrix of Section 55 to secure your 16 marks? I demand you review this exact sequence, draw those tables out by hand, and memorize the Bear Act provisions before you even think about walking into that examination hall. All right, court is adjourned. Study hard.